Top story on left, right and centre. Sedition is once again the subject of debate. There's a crucial hearing on the sedition law that is coming up in the Supreme Court on Tuesday, that's the 10th of May. The Apex Court will be hearing a batch of pleas, a batch of petitions challenging the constitutional validity of this colonial era law. The pleas filed by the Editors Guild of India and Major General retired S.T. Bombatkre state that the law causes a chilling effect on free speech and is an unreasonable restriction on the fundamental right to free expression. And hours before this hearing on Saturday, the centre came out with its stand. The centre came out defending the sedition law and asked the Supreme Court to dismiss the pleas challenging it. Filing its submissions on Saturday evening, the central government backed the 1962 judgment in all respects, saying that there's no need to either review the judgment or relook at the validity of Section 124A. In a written submission, the centre told the three-judge bench that is led by the Chief Justice N.V. Ramana that the verdict in the Kedarnath Singh versus the state of Bihar upholding sedition law is binding. It also said that a three-judge bench cannot examine the validity of the law. Basically, the centre has defended the law. It says there are enough safeguards already in place to balance constitutional rights of the citizens of India, and the needs of the state. So, what is the sedition law? Let's take a look at that first. Drafted by the British historian, the politician Thomas Macaulay in 1837, sedition was defined as an act by, and I'm quoting here, whoever by words, either spoken or written, or by signs or by visible representation or otherwise, brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India. The sedition charge, which was included in Section 124A of the Indian Penal Code in 1870, was imposed by the British colonial government primarily to suppress the writings and the speeches of prominent Indian freedom fighters. So writings of leaders like Mahatma Gandhi, Lokmanya Tilak, Jogendra Chandra Bose were all suppressed, and they were tried under the sedition law for their comments about the British rule. And since then, concerned over the enormous misuse of this law on sedition, the top court in July last year, the Supreme Court in July last year, had asked the centre why it was not repealing this provision used by the British to silence people like Mahatma Gandhi, to suppress India's freedom movement. And what is the punishment as per this law? Well, as per Section 124A, sedition is a non-bailable offence. It's punishable with imprisonment from 3 years up to life, along with a fine. A person charged under this law is also barred from a government job. Their passport is seized by the government. Incidentally, the sedition charge was abolished by the UK, by the United Kingdom, in 2010. And so since then, what have we seen in India since 2010? Well, as per the 2020 National Crime Records Bureau report, the NCRB report, we've had about 70 sedition cases filed in 2018, but not one single person convicted. Similarly, seeing about over 90 cases in 2019, only about 2 convictions. In 2020, over 70 cases and only 1 person convicted of sedition. And of course, we've seen many headlines over the past few years related to cases of sedition charges being invoked, whether it was the environmental activist Disha Ravi for sharing a toolkit for a global online campaign that supported the farmers' protests. We've seen sedition charges against activists Omar Khalid, Natasha Narwal for alleged inflammatory remarks made or speaking at the anti-CAA meetings, against the journalist Siddique Kappan, of course, for going to Hathras, proceeding to Hathras, where a 19-year-old young woman, a Dalit woman, had been gang raped, to report on that story. For activists Sudha Bhardwaj, Varavara Rao, Anand Teltumde, the late Father Stan Swami, for making speeches at the Elgar Parishad meetings in the before the violence hit in Bhima Koregaon. So we've seen headlines like this, but concerned about the enormous misuse of this law on sedition, the top court in July, like I said, asked the centre, why is it not repealing the provision used by the British to silence people like Mahatma Gandhi? Now, the Supreme Court has urged for limits to the sedition law. They pointed out that journalists are also entitled to protection. But in the last 24 hours, we've seen the government come out. They have come out, with swords blazing to defend this law. They say that it does not need to be amended or changed, improved. It is fine as it is. Now, as sedition comes under fire in the Supreme Court, the big question on LRC is, does India need a sedition law, or is it time to scrap this colonial era law? Joining us on the show tonight, we have Prashant Kanodia, National President of the RLD Party of the SASC wing. He's a former journalist. He's been charged with sedition himself over a tweet against the former Army Chief Bipin Rawat. We have Asim Trivedi, cartoonist, who's been charged with sedition too. Colin Gonsalves, senior advocate with the Supreme Court. Satyapal Jain, additional Solicitor General of India, member of the BJP, the National Executive Committee, and Ashutosh Srivastava, an advocate with the Supreme Court who supports the BJP. But first I want to start with Asim Trivedi, an award-winning cartoonist who quit or had to quit after he was arrested by the Mumbai police in 2012 under this colonial era section of the IPC. Asim, you were just 24 when you were booked for sedition. Is that right? And this is because you made cartoons that talked about corruption during the India Against Corruption movement. You spent how much time in jail behind bars, and has this led to you censoring yourself?
5 दिन कुल मिला के 8 तारीख से लेकर 12 तारीख तक, जबकि मैं बेहद खुशनसीब था कि मुझे काफी सपोर्ट मिला। उस दौरान मतलब यूपीए गवर्नमेंट के खिलाफ इंडिया अगेंस्ट करप्शन एक बड़ा मूवमेंट था, तो बहुत सारे लोग सपोर्ट में आए थे। लेकिन जैसे हम इधर देख रहे हैं, बहुत सारे लोग उतने खुशकिस्मत नहीं है, बहुत लंबे लंबे समय उनको जेल में बिताना पड़ रहा है। तो मुझे लगता है कि एक तरह से आपकी वॉइस को अगर कोई किसी तरह से फ्रेम कर दे या किसी तरह का आप पे एक लेबल लग जाए, तो हमेशा वो बना ही रहता है। और कई बार जब आप कोई काम कर रहे होते हैं, जैसे आप कार्टूनिस्ट हैं, आप एक्टिविस्ट हैं, आप जर्नलिस्ट हैं, तो आप आमतौर पे वही करेंगे ना कि जो आपका काम आमतौर पे डिसअफेक्शन ही दिखाएगा आपकी गवर्नमेंट के प्रति। आप कहीं ना कहीं क्रिटिसाइज ही करेंगे, आपका ये काम है। और अगर कोई कानून है जो कहता है कि इस तरह का क्रिटिसिज्म या इस तरह का डिसअफेक्शन अपने आप में एक क्राइम है, तो आपको जाहिर है कि मुकदमा लड़ना पड़ेगा। तो मैं यही कहूंगा कि मैं फिर भी लकी था कि सडिशन मेरे ऊपर से हट गया। हालांकि मुकदमा अभी भी चल रहा है, अभी भी मुंबई बांद्रा कोर्ट में डेट्स बढ़ रही हैं, लेकिन बाकी के धाराओं में। लेकिन बहुत सारे लोग हैं जो सडिशन में ही बहुत लंबा वक्त गुजारते हैं, उनको उस तरह का सपोर्ट नहीं मिल पाता।
So it's been 4 years. So you're saying, how many years has it been? You're saying you're still facing these charges, you're still fighting this out in court?
जी 10 साल हो गए। मेरे ऊपर 3 धाराएं थी, एक सेडिशन था और एक आईटी एक्ट का 66A 2015 में सुप्रीम कोर्ट ने हटा दिया, और एक और धारा है नेशनल एम्बलम एक्ट 1952।
So that's the reality. It could take 10 years, it could take longer, and there are many. The conviction rates are just so low. I already read out those numbers to you. Journalist Prashant Kanodia also joins us. He was booked for defamation among other charges because he made a Twitter post about the UP Chief Minister Yogi Adityanath. He was then arrested for 2 months. Is that correct? Mr. Kanodia, आप बताइए, what had happened with you?
Basically, UP government arrested me a couple of times, not once, and there was also a sedition case. But apart from this, there are a lot of sedition cases already filed against me, under which I haven't been arrested yet. So it will be used as a political tool in near future. Whenever they feel they can arrest me back and they can put me in jail. And the main intention behind arresting me or other activists or maybe cartoonists, whatever Asim has faced, it is not because they feel that they can put us behind jail for a longer period of time, but it's to basically harass us. Because the way they harassed Vinod Dua, they harassed Disha Ravi, and the way our passport is being blocked by Indian government, so we can't travel abroad. I got admission in London School of Economics, and because of this regime didn't allow me, I unable to go there and to pursue my higher studies. So these are the basic things this government wants to do, and I think there is no need of having any such colonial law. And why should there is a need of weaponizing any law on their own people? The law needs to protect the people. It is not used against people. So this colonial law, whether it's sedition, whether it's UAPA, whether it's NSA, I think it's high time we need to scrap, and everyone needs to agree on this issue.
You said, Prashant, you said that they use it to harass you, but are you meaning to say that they're hoping to silence you? Because you're a journalist, right? Because you also tweeted that sedition was used by the British government to suppress voices like Bhagat Singh, Rajguru, Sukhdev. So you believe, I think I can say this, that you believe that this is an attempt to basically silence anyone who is critical, silence anyone who could play the role of a watchdog. You've been targeted, or you're saying harassed because you're a journalist. Is that correct?
Absolutely, because they are basically setting up some examples to the society. Like, if you have some unfavorable opinion of government, so these are the examples: Asim Trivedi, Prashant Kanodia, Disha Ravi, Vinod Dwal, and these are the examples. So people look at them, they get fear of their family pressures, so they say don't speak, don't write anything, otherwise they will put you behind the bars. So they are setting up examples, but we know there are examples in our history. Maybe Mahatma Gandhi, Lokmanya Tilak, Bhagat Singh, and many more.
Mr. Satyapal Jain, why does India need a law like this in the first place, 70 years after independence? I want to quote what the centre said in its submission to the Supreme Court on Saturday, saying there's no need to review this judgment. There are enough safeguards already in place to balance constitutional rights of citizens and the needs of the state. Yet, we just read out the litany of names, whether it's Disha Ravi to, Stan Swami. Why do we still need a law like this?
See, there are two aspects of this problem. One is the intention behind the enactment of the clause, and which has been upheld by the Honorable Supreme Court, 3 judges of the Supreme Court in Kedarnath Singh's case. See, the law must stand on the law book, because ensure the safety, integrity and unity of the country, you have to curtail those forces who are acting in the anti-national activities. It does not curtail the dissent. It does not curtail the difference of opinion. It does not curtail the criticism of the government.
Prashant Kanodia tweeting something about the Chief Minister.
Please, I have heard all that. Give me just 1 or 2. See, there are two aspects. One is the law, which is required, which has been upheld by the Honorable Supreme Court till date, which is final. Second, number of examples are being given of misuse, abuse of the law. See, if you apply that formula, I don't think there is any law in India or anywhere in the world about which there are no allegations that in one or the other case it has been misused. If it is misused, courts are the best guarantee to see that justice is done to the citizen. So therefore, simply because there is an apprehension or there are certain examples where it has been misused or abused, if you start repealing the law on that ground,
but Mr. Jain, my question to you, sir,
as a lawyer can tell you, you will not be able to save any law, because
but
there
Mr.
will be
Jain, my question to you is the admission by the centre before the Supreme Court that there is no need for making any changes to this because it is not misused.
Because of the fact that Kedarnath Singh's case, the Supreme Court has upheld the validity of this law.
So I'm talking about the centre making a submission. So I'm talking about the centre making a submission to the Supreme Court that there are enough safeguards in place to balance constitutional rights of citizens and the needs of the state. Can you tell me what those safeguards are there in place?
Yes, because the Supreme Court in Kedarnath Singh's case said simply criticism or having difference of opinion will not amount to decision. Supreme Court says in Kedarnath's case, activities involving incitement of violence or intention or tendency to create public disorder or cause disturbance of public peace. How can you defend a person who intends to create violence? And you see in Supreme Court, in Balwant Singh's case, there were certain slogans raised. Court said, no, this doesn't amount to sedition. So courts are the best guarantee to see that no injustice is done to any citizen. Simply because there are certain cases.
Colin Gonsalves, Mr. Jain says, how can you defend somebody who is going to create, violence in society, who is going to be a disruptive element in our society? How can we stand by somebody like that? So I would have to ask then, if they are such a serious issue, such a serious problem to the country, why do we have such low conviction rates? Which means all these people are walking around freely in our society.
Wait, before I answer that question, let me first of all clarify 1 or 2 things which is essential for this discussion.
Please.
124A, as you showed on your screen, makes even words, strong words, capable of coming under the umbrella of sedition.
Okay.
In Kedarnath Singh's case, the Supreme Court said, words are not enough. This is unconstitutional. You must have strong words and you must have violent actions against the state. So the first part of Kedarnath was correct. But having said that, the Supreme Court made a huge blunder in not striking down the section. After saying it's unconstitutional, mere words cannot be a crime, must be words plus very powerful action. The Supreme Court blunder was in not striking down the section. What is the consequence when a policeman opens his book today? He sees 124A, strong words. Therefore, all the journalists on your panels, all the cartoonists, because it says words or signs, all of them who are criticizing the government, the policeman opens his book and says sedition. That's why it's very important now that the Supreme Court strike down the section. The blunder created in Kedarnath, what the Supreme Court did not do, and is totally a Supreme Court induced crisis in the country. Had Kedarnath done it properly and struck down the section, which is what we are asking for today, all these crimes would, all these cases against journalists would never have existed. And the question I want to ask is, it's not misuse. It's not misuse of the law. If the law by itself says strong words is sedition, then it's a correct use by policemen, because the Supreme Court made the blunder of not striking down. And that is what we are asking today in the Supreme Court. Strike down the law. This colonial law which the central government supports, you will see that ultimately what our British masters did to us, arresting us and jailing us for criticizing the colonial powers, the central government is doing exactly the same thing today. Decades later, it takes exactly the stand of the colonial government. Any words against the state, against ministers, any word against them, and you'll go to jail. So now we must strike down that section. That's the job of the Supreme Court. And it's a bit late. The Supreme Court has been too slow, far too slow in addressing the issue of sedition. And our young activists are in jail suffering on account of judicial slowness and inactivity.
Sanswamy died in jail. I'll come back to you, Mr. Gonsalves, but Ashutosh Srivastava, to respond over here. So you've heard what Mr. Gonsalves just had to say, yet we saw the centre in its admission to the court saying essentially there's nothing wrong with this law. Actually, it suits our government, not just this government. It suits governments per se, governments in power, to have such laws at their mercy.
See, whenever such kind of information is brought to the investigating agencies like police authorities, now it is expected that the police authorities or any investigating agency will apply the law by application of mind, and they should understand that this section 124A is a serious offense and it should be implicated in rare cases where such kind of evidence. But that's not the case. Yes. So now what I want to say here is that the law in itself is not wrong as such, because if any such thing really happens, then what happens? If somebody tries to bring disaffection towards any government which has been elected and formed as per the law of this country, then what happens? Then what law will apply in that case? Now, if 124A is being applied erroneously or maybe just to abuse the process of law, in that case, I think accountability of the investigating agency... No, but would you say that legally, I mean, common sense would say that if you have such a low conviction rate, it means that this law has been not applied Yes. So in that case, the accountability of these investigating agencies have to be made out. I think the guidelines have to be made out by the Supreme Court. Mr. Satyapal Jain, could you respond over here about why we have these very low conviction rates? Could you explain why we have 100 cases filed, 1 person convicted?
There are 2-3 reasons for that, which are very glaring and which are very, noticeable in the normal jurisprudence of working of the law. Number one, there is a very strange principle of criminal law. if there is a doubt, you will be booked. If there is a doubt that you have committed an offence, you will be booked for criminal trial. And if there is a doubt, you will be acquitted. So doubt is sufficient for booking you, and doubt is sufficient ultimately for acquitting you. Unless you prove to the hilt, you can't be convicted. Number two, in these cases, as Mr. Srivastava rightly pointed out, there must be some search or research or investigation into working of the agencies also, because people involved are not small fries. Most of the cases, the people involved are big people.
Mr. Jain, these agencies are responding to the masters above. We can't pretend that they're independent now. They're taking their orders from above.
Is there any reason that they are not able to properly investigate? And what is the reason? Third is whether the police officers or the people booking the people under this section, they do understand the real intention behind this law or not. Objectively speaking, if we study that, there will be no problem. But I totally agree with Mr. Srivastava, and I am of the firm view, this law must stand. It has stood the test of the time, and all the arguments given by my learned senior colleague were argued before Kedarnath Singh case also. The Supreme Court did not agree with them.
He called it a blunder. He called it a blunder. Okay. We have about 30 seconds.
Indian judiciary has the power to set aside even a law enacted by the Parliament unanimously, National Judicial Appointment Commission, unanimously passed by both houses of Parliament.
That's why it's a critical case coming up before the court on Tuesday.
The judiciary has upheld this law. Same judiciary has upheld this law.
Colin Gonsalves, 30 seconds, just want to give you the closing argument over here. So it's not that some guidelines need to be set down so it can be fixed, things can be made better, you need to make sure it's not misused. You believe this just needs to go.
Era when it's an unconstitutional law, it can't remain on the statute book, because then policemen know they can misuse this law. So to prevent the misuse of the law, the most important thing is that this law must be struck down. Once it disappears from the IPC, it can't be used anymore. It can't be misused anymore. And that's the reason why the police and the BJP are strongly standing by the law, because they want to stifle dissent against the central government. Stifle dissent.
All right, that's why all eyes on the Supreme Court this Tuesday as this crucial hearing comes up
from speaking
on the
That's
sedition
the reason
law.
why they love this law, colonial law. They love this colonial law.
Thank you all for joining us tonight with your time. Thank you for joining us on Left, Right and Centre.